Can you refuse custody of a child? My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. Can you refuse custody? Really, it creates a scenario where the court has ordered, let's say, that mom has the custody, dad is not happy about it, so he is going to refuse to drop his kid off and make the custody change. Can he do that? Well, it's really not a question of can he do it. The real question is, can he do it and not get into serious trouble with the court? The answer to that question is no, he cannot. Matter of fact, I have had situations where our firm has represented parties in a custody battle. We had the mom, and there was a question of custody of an 11-year-old child, and dad had prearranged with the mom that if it doesn't go his way in court, and if he loses custody, and he's going home from the courthouse with mom, they arranged that when the car stops at a certain street, the kid should run out of the car, run away at the red light, and dad would be waiting across the street with an open car door to cart the child away. They literally tried to get away with this, and that's exactly the plan that they did. And you know what happened? They got caught. And once they got caught, not only did the court restore the custody, but the court severely penalized the father and denied him any parenting time without a supervisor there. And you know what happened? He couldn't afford to pay for the court a supervisor there, which charges like $30 or $35 a visit. And he ultimately ended up in a situation where he hardly ever saw his kid. Ever. Why? Because he decided to take matters into his own hands. People, it's a very, very bad idea. Don't do it. If the court orders that you lose your custody and you're upset about it, work with it. Try to create a scenario where you're complying with the custody. File an appeal if you want to. File a request later on down the road for reconsideration. Do something within the boundaries of the court. Self-help is, in the long run, not going to be of any help at all. So you need to understand that. The consequences are severe. You take the child away in violation of the court order, you can be held in contempt. Your parental rights can be severely limited. They can even ultimately be terminated. So you don't want to be in a situation where you set those dominoes falling in motion, okay? You have to understand that in cases that go to court, there's typically someone who wins and someone who loses, okay? Odds are one is going to be a winner, one's going to be a loser. Don't be so confident that you're going to be the winner because you may or may not. And these fail-safe plans that if you lose, you're going to steal the child anyway, that's just a way for you to end up behind bars. So let's not do that. Work within the system. The system is there for both parties. If there's a legitimate reason why the child should be with you, have your lawyer file the appropriate motions. Get the evidence before the court. Tell the court why you think mom is no good. It's got to be something that goes to the child. You don't like the mom because you feel slighted because there was a divorce. That's not going to carry the day. That's not going to be sufficient reason for the court to grant you custody because you have ill will against the other party. You've got to show and focus on the things that are important. Now, a good lawyer will tell you what the things are that you need to focus on. And if your lawyer is telling you something and you don't want to focus on that, so you think you'll get another lawyer who will allow you to focus on the garbage, all that's going to happen is you're going to lose. There are plenty of good lawyers out there who will tell you, look, these are the factors. This is what you need to prove. Bring evidence for those things, and you have a shot at it. Now, a lot of times good lawyers are not given the appropriate evidence. A lot of times we at the firm will tell our clients, if you want custody, you need to show A, B, C, and D. Okay? That's what you need to show. Do the clients provide that information, that evidence, those exhibits? Sometimes they do. And sometimes they don't. Sometimes they think that what they have is good enough. But good lawyers will tell you, I'm sorry, I'm reading these texts. They're not going to cut it. This is a bunch of texts where you're telling the other side they're no good. That's not evidence that they're no good. That's just your opinion. The guy in the black robe has his own opinion. Focus on evidence. Evidence means something that's an unbiased proof that anybody objectively would look at it and say, yes, that shows Proposition A, Proposition B, Proposition C. It shows what you want to propose as evidence. Good, that's proof. You want to show a bunch of self-serving stuff that nobody's going to buy? The court's not going to buy that either. Lawyers are experts in certain things. Amongst the things that lawyers are expert at is evidence and what evidence is necessary to prove what elements. Speak to your lawyer, put your pride aside, and get the things that he or she says you need. If you can get them, great. If you can't get them, then don't expect the judge to say, well, I'm going to give you custody anyway. Expect that it's probably going to be a shared situation, or maybe the other side will get custody. If you feel you should have the custody, but you cannot produce evidence to support it, you know what? Maybe you shouldn't have the custody. Maybe it's better that the other guy have the custody. Or maybe it's a shared situation because one party's not better than the other. A paucity of evidence, an inability to produce something that actually supports a case one way or another is more likely than not evidence that it shouldn't be one way or another, but it should be shared. So this is a hard reality for a lot of people to accept. And not all cases are like this. Some cases, there's definitely a favorite. There's definitely somebody who should win. But my experience is that a lot of times the courts won't say that, they think the other mom's better or the other person's better or you're better or the dad's better, the mom's better. They won't say that, but they'll simply say, look, the evidence is lacking. Show me evidence and I'll make a decision that's a little bit different. That's what you got to keep in mind. You have to be able to produce the evidence that supports what you say. Just because you say it doesn't make it so. Just because the other side say it doesn't make it so either. Evidence is the key. If you have any questions about your particular case, reach out. We'll be glad to help you out.
248-588-3333. 248